If you are over 65 and you have a will, this video is for you. Not because something is wrong with you, because something is almost certainly wrong with the document. Not the intentions, the mechanisms. 3 specific things that feel completely reasonable when you write them and create serious, expensive, sometimes irreversible problems for the people you are trying to protect. One of them is likely sending your most valuable asset through a 14-month court process after you are gone. One of them is leaving your children's inheritance exposed to their creditors, their divorces, and their worst decisions the moment it transfers. One of them was put there to keep the peace, and is statistically the most likely thing in your estate plan to start a family war. 3 things, all of them fixable, none of them free to ignore. This video is for educational purposes only and is not legal, tax, or financial advice. Consult a qualified estate planning attorney before making any changes to your specific situation. My name is Daniel Kim. Every week I break down the financial rules, the legal traps, and the strategies that protect retirees from the things nobody else is explaining clearly. If that sounds like something you need, subscribe right now and turn on notifications so you never miss a video. Let's get into it. Thing number 1, your house. Not the house itself, the way it is titled. If your home is titled in your personal name and your will is the document you are relying on to transfer it to your children, you have just sent your most valuable asset directly through probate court. And depending on the state you live in, that means your family is looking at 9 to 18 months of court process, public record of every asset you owned, and legal fees ranging from 3 to 8% of the gross value of the estate before anyone receives anything. On a $500,000 home, 3 to 8% is $15,000 to $40,000 gone before your children see a dollar. And in California, where probate fees are calculated on the gross value of the property, not the equity, a family with a $600,000 home that still carries a $200,000 mortgage pays probate fees on the full $600,000, not the $400,000 they actually own. The debt does not reduce the fee. The average probate process takes 16 months, according to data from estate settlement researchers. For larger estates or any situation where heirs disagree on anything, 3 to 5 years is not unusual. During every one of those months, your family is paying property taxes, insurance, and maintenance on a home they cannot legally sell or transfer because the court has not released it yet. Here is what makes this particularly hard to watch. Every single one of those costs is optional. When a home is titled in the name of a revocable living trust, it bypasses probate entirely. The transfer to your heirs happens privately, immediately, and without court involvement. There is no filing fee. There is no 14-month wait. There is no public record of what you owned or who received it. Your family does not have to hire a probate attorney. They do not have to appear in court. They follow the instructions in the trust document and the home transfers. Setting up a revocable living trust typically costs between $1,500 and $3,000, depending on the state and the complexity of the estate. On a $500,000 home, that is the difference between paying $1,500 to $3,000 now, or your family paying $15,000 to $40,000 after you are gone. During the worst months of their lives, there is one critical detail that most people miss, and it voids the entire strategy. The trust only works if the property is actually retitled into the trust's name. I cannot tell you how many retirees have a trust document sitting in a drawer that was never funded. They paid for the trust, they signed the trust, they filed it away, and their home is still titled in their personal name. Check the deed on your home this week. If it does not say the name of your trust, the trust is decorative. Call your attorney and get the deed transferred. Thing number 2, the fixed distribution instructions that feel fair and will cause a family war. This is the one that sounds the most reasonable in the room where it gets written and does the most damage in the years after. Most wills written before age 75 contain some version of the same language. Assets are divided equally among children. Cash goes outright at a specific age, maybe 25, maybe 30. Property is to be sold and the proceeds split. Clean, simple, equal. The problem is not the equality. The problem is the word outright. The moment an inheritance transfers to a beneficiary outright, it is no longer protected by anything. A child going through a divorce that year? In many states that inherited money can become a marital asset. A child with a civil judgment against them from a lawsuit or unpaid debt. Creditors can reach it. A child struggling with addiction or mental health issues. The money can be gone in months, and there is nothing you can do about it from the other side of that transaction because you already gave it to them with no conditions. An estate planning attorney who works with retirees daily described a case where fixed cash bequests written into a will left heirs with no choice but to sell real estate to cover the distributions because the estate did not have enough liquid assets to pay the fixed amounts. Property the retiree had specifically wanted to stay in the family was sold to strangers to fund cash gifts the will mandated. What feels like fairness and simplicity on the page becomes an inflexible legal instruction that nobody can override once you are gone. The mechanism that fixes this is a trust structure for distributions. Instead of transferring assets outright at a specific age, a trust can allow distributions under conditions, over time for specific purposes like education, housing, or a health emergency, with protection from creditors and divorce proceedings during the period before full distribution. Assets held in a trust for a beneficiary are typically shielded from that beneficiary's creditors, and in many cases from divorce claims, because the beneficiary does not own the assets outright until they are distributed. This does not mean your children never fully inherit. It means the inheritance travels to them with a set of guardrails that protects it from the specific scenarios you cannot predict from the day you write the document. There is a second version of this problem that shows up constantly in wills written 10 or 15 years ago and never revisited. Fixed dollar amounts. A will written in 2009 that leaves $50,000 to one child and the remainder to another made sense at the time. In 2026, that same provision may dramatically shortchange one heir relative to your current intentions because inflation and asset appreciation change the math on what your estate is actually worth. If your will specifies fixed dollar amounts to specific people, look at those numbers today against your current asset picture. The will enforces the number you wrote, not the intention behind it. Thing number 3. The two co-executors you named to keep the peace. This is the decision that feels like the kindest one in the room. You have multiple children. You love them equally. Naming only one as executor feels like it picks a favorite, so you name 2, sometimes 3. It feels fair. It is not. An estate planning attorney at a California law firm described the pattern she sees most often with retirees. Seniors name multiple children as co-executors specifically to avoid offending anyone. And that one decision, made to preserve family harmony, reliably produces the most family conflict of anything else in the document. Here is the structural reason. An executor has legal authority to act on behalf of the estate. When you name 2 co-executors, most states require both signatures on every transaction, every bank withdrawal, every property listing agreement, every creditor negotiation, every court filing. If the 2 co-executors are not in perfect agreement on every decision, the estate stalls. If they disagree about whether to sell the house, when to sell it, or which realtor to use, nothing moves until the disagreement is resolved, which sometimes means additional legal proceedings to break the deadlock. And here is the part that turns families into courtrooms. Even $100 left to someone in a will gives that person legal standing to contest the estate's administration in probate court. If you have even a mildly estranged family member receiving a small bequest, they have the ability to challenge the will's validity. The co-executors now have to defend the will in court to prove it was signed under sound mind and without undue influence. On top of managing the estate, on top of grieving, one executor, one backup if the primary cannot serve. That is the right structure. The person you choose should be organized, financially responsible, and willing to have uncomfortable conversations with family members. Not the person most likely to cause the least offense at Thanksgiving. Those are rarely the same person. If your will currently names 2 or more co-executors, talk to your attorney about restructuring it. If there is a family member you are trying not to hurt by this change, that is a conversation you can have now, while you are alive, rather than leaving it to explode during probate. Your complete checklist. 1. Find the deed to your home this week. Read the name on it. If it is your personal name and not the name of a trust, your home is headed to probate court when you die. Contact an estate planning attorney about establishing a revocable living trust and retitling the deed. The cost is a fraction of what probate will consume. 2. Pull out your will and read the distribution language. If any asset transfers outright with no conditions, look at who is receiving it and what their current life situation looks like. Divorce, debt, health issues, financial instability. Any of those factors are reasons to talk to your attorney about a trust structure for distributions instead of an outright transfer. 3. Count the executors. If there are 2 or more names in that role, understand that you may be creating exactly the conflict you were trying to avoid. 1 executor, 1 successor. That is the structure. None of this requires rewriting your entire estate plan. In most cases, it requires 1 conversation with an estate planning attorney and a few document updates. The cost of those updates is measured in hundreds to low thousands of dollars. The cost of not making them is measured in months of delay and percentages of everything you spent your life building. This is Daniel Kim. If this video helped you, hit the like button right now. It takes 1 second, and it helps this reach more retirees who need to see it. Subscribe and turn on notifications if you are not already. Drop a comment and tell me which of these 3 is in your will right now. I read every single one. The most common situations become future videos. I will see you in the next one.